Hi, everybody. Thanks for joining me again today. We're talking about medical certifications today. And we'll go ahead and bring up a slide, the medical certification slide. So today we're going to talk about medical certification and can you require one? Now that seems a little bit odd, but with the new Pregnancy Workers Fairness Act, some confusion about this probably is being felt. Let's start with the Family Medical Leave Act. The Family Medical Leave Act has a medical certificate that requires the medical provider to read the definition of a serious health condition so they can check the box and say, yes, this is one. And without going through all of the individual definitions of a serious health condition, what's important to note is that when you send that medical certificate, and please send your own, so the doctor fills out your certificate, so you get consistent information. We've got one that we've designed years ago, and we keep tweaking it to make sure it is as effective as possible to get those medical providers to provide us the data. So you've got a medical certificate that is asking the medical provider to read the definition of a serious health condition and verify that their patient has a serious health condition under that definition. And then once they've determined that, we're asking them, how long do they need to be gone? What's that return to work date? And can you please clarify they really can't do any of their job? Now, we're doing all of that because we're trying to get enough information about whether they may be protected under the ADA. Keep in mind that if you've got a workers' comp case, you're already getting a medical certificate. So the question you can ask yourself now is, when I get that workers' comp medical certificate, is that good enough for FMLA? And I would suggest that in most cases, it's going to be, unless it's confusing and doesn't provide you enough information. So when you've got a FMLA certificate, what my rule is if I have any other medical certificate that the employee provided us that provides me enough data to fill out that FMLA certificate, I'm not requesting another one. And if I've got a workers' comp certificate, so I know there's being treated by a medical provider, then I'm not needing another one if it provides me enough data. Now, having said that, if it does not provide you enough data, what do? Well, you cure everybody. And if you haven't heard about curing, it's probably because attorneys aren't implementers, they're litigators. And so they're teaching you about the regulation. What we're talking about over these podcasts is how do you implement these regulations? And how do you implement them when you've got 2 or 3 of them happening at the same time? And maybe even a company policy that does something else. So this is the important strategies that we're discussing. These are what causes lawsuits. These behaviors that contradict a standard operating procedure because we're focused on a regulation instead of the big picture of how all the regulations are interacting right now and which one has the highest level of standard that we have to meet first, and then we meet the others down the line. For example, FMLA has the highest standard for job protection and medical benefit protection, higher than ADA, because ADA is just job. So what we're talking about, the FMLA certificate, if it can be filled out with any other medical data you've been provided that you feel is valid, please don't ask for another one. Fill it out and use that data. But if you don't have enough information, and even if they gave you a FMLA certificate, but it isn't accurate, it doesn't have a return to work date, it doesn't have an end date, it doesn't say unknown, it just isn't filled out. That's called curing. And we cure with a very specific process. It's dictated by FMLA. And if we can't get what we need from curing, we're going to go to the next level and we're going to go to second and third opinions. And that's always what we're going to do. Because once we cure, if we don't get the answer we need to get a second opinion to see if they can help us understand what's going on. And if that doesn't help us, we're going to a third. So these are very specific strategies for dealing with fraud, for dealing with abuse, for dealing with extensions. Keep in mind, when a medical certificate for FMLA exhausts, the end date has been reached. There are no extensions under FMLA. They have to provide a new certificate. And if they're providing a new certificate, everybody, they're also getting another 2 weeks to do that. So keep in mind that FMLA doesn't have extensions, neither does ADA. They have to reapply and be eligible again for the extra leave or the additional accommodation they're requesting. So that's FMLA. Now let's talk about the American with Disabilities Act, because remember, when FMLA ends, ADA begins all the time, every time, no matter what. So if FMLA is about to end and you're on your 10th week, let's get a certificate to the employee so they can fill out our ADA medical certificate. Now, our ADA medical certificate is an evaluation form. We've designed it for the doctor and the employee to work together by evaluating their job description and letting us know what functions of the job they can perform, what functions of the job they can't perform, and why. Is it environmental? Is it physical? Is it mental? We need to know, because then we can accommodate, because we've got enough information. So we are sending a very detailed 4-page ADA medical evaluation form for the employee to fill out with their doctor. And it is the employee's sole responsibility, by the way, to get all of these certificates to us, everybody. Not yours, theirs. We don't call doctors. If we call workers' comp doctors, we call everybody's doctors. So don't call doctors. Explain to the employee what they're responsible for. So when we've got a certificate from ADA that tells us how their disability impacts their ability to perform the essential functions of the job, now we can determine how we can accommodate, because we're accommodating on how they perform the job, and we're accommodating those particular challenges. Okay, so under the ADA certification, once you've got that certification, you're engaging in the interactive process, and that's the process. Once you have your ADA medical certification, then you've got the information you need to engage in the interactive process. Now, keep in mind, we also have FMLA, military, and extingency. Those are not medical certificates per se, because they are taking care of a family member. And so there is a separate certificate or a separate section of the certificate for family members. If you're taking care of a family member, the certificate we're looking for is to explain to us how you need to personally participate in taking care of that family member and when it's needed and necessary. So now with American with Disabilities Act, we also have the Pregnancy Workers Fairness Act. And you are being told you can't get medical certification for this. And that is accurate. If you have a basic pregnancy challenge with anticipated known accommodations, extra breaks, things like that, we don't need medical certification for that. We're just simply looking for the date the baby is due, so we understand how long the various accommodations may be necessary. But remember, if it's an undue hardship to accommodate even a pregnant female, you are not required to accommodate them. At that point, they would probably put on FMLA leave instead. But our whole goal with the Pregnancy Workers Fairness Act is to keep employees working when they're pregnant. And so we're providing basic standard accommodations of extra time and extra breaks for them to take care of themselves. If you get more serious requests, at that point, you may be getting additional medical documentation, because the nature of the request is not normative. It's not normative. Our next issue is workers' comp. So we've talked about FMLA, we've talked about ADA, and now we're talking about workers' comp. And as I mentioned before, workers' comp runs concurrent to FMLA, or it runs concurrent to ADA. So then with workers' comp, if they're eligible for FMLA, we're starting with FMLA if they need leave. And if they've got restrictions, we're starting with ADA to accommodate them in the workplace. But it all starts with a medical certificate. So we are absolutely expecting a medical certificate with workers' comp. That same workers' comp medical certificate is probably all you need for FMLA and may even be all you need for ADA, except for the length of time. Workers' comp is often 30 days, 30 days, 30 days, and that doesn't work under ADA. We need them to tell us the length of time they'll be gone on the medical certificate so we understand if this is an unpredictable leave or if there's a real anticipated return to work date. And then you get to your company policies and your vacation and your sick leave. And of course, you've got your own procedure for getting those certificates and how they get access to those leaves. You may have a leave of absence request form that they fill out. Just make sure that they fill it out correctly if you're going to pay them. Don't let them get a buy with not following company policy to get paid for sick leave. And then last but not least, you've got LTD and STD if you are a big enough employer, and they have their own medical certificates. And what's important about LTD and STD is that even if they are or are not eligible for your STD or LTD program, that has nothing to do with their eligibility with a medical certificate under FMLA, workers' comp, or ADA. It is a different assessment, and they are different regulations, and they're different criteria. Don't use one to dictate your behavior in the other, except for with workers' comp and with FMLA and with ADA. Once you get one certificate that provides you enough data, you don't need to keep reaching out for more unless the original certificates were not clear. Now, the last thing I want to talk to you about, and we just added that box to our slide so you would be able to be aware of it, is the return to work release. Yes, you must be consistent for all medical leaves. If you are requiring a return to work release when they come back from a medical leave after 3 days, 5 days, maybe they have to be gone 30 days before you require one. All employees have to be provided one. So you can't require a return to work release for workers' comp, but not one for FMLA and not one for pregnancy. Everybody has to provide one if anybody has to provide one. So that's medical certification, everybody. And there's more details to all of this, but this is the high-level approach. I hope that helps. Let us help you become the expert. Join us at the Ultimate Guide to Leave and Accommodation Management in October in Chicago. The second day is nothing but ADA accommodation blueprint, and you come to one day only if you like. Bye, everybody.